Testamentary capacity. In order for a document to constitute a valid will under California law, the testator must have the capacity and intent to form a will through that document, and 2, the will must meet the formation requirements. A testator will have adequate capacity to form a will if they are 18 years of age or older, 2, they understand the extent of their property, i.e., they know what property they own, 3, they know the nature of their bounty, i.e., they understand who their issue and or their spouse is, among other relatives, and 4, they intend for the document to constitute a will. Will formation. For a non-holographic, i.e., not handwritten, will, there are 5 formation requirements. First, the will must be in writing. Second, the will must be signed by the testator, or by a third party under the direction of, and in the presence of the testator. Third, the testator's signing of the will must be in the presence of 2 witnesses. Each witness must be present at the same time to see the signing. Fourth, the witnesses must sign the will during the testator's lifetime. Fifth and finally, the witnesses must know that they are witnessing the execution of a will. Revocation of will. A will may be revoked by either physical revocation or 2, a later testamentary instrument. Physical revocation occurs when, among other things, there is a burning, tearing, crossing out, or obliteration, i.e., erasure of terms of the physical will document, and the testator through such actions intended to revoke the will. In the event that there are multiple copies of a will, the physical revocation of one copy will create a presumption that there has been a revocation of the will, even if other copies have not been physically revoked. Revocation by subsequent instrument. A later instrument revokes a prior will if the later instrument expressly states that it revokes the prior will, or 2, the later instrument creates an implicit assumption that the former will is revoked. 4.2, a later will that deals with the entirety of the testator's estate, and therefore leaves nothing for the previous will to distribute, constitutes sufficient implicit evidence of revocation. Holographic will. In order to have a valid holographic will, the document must be in writing, 2, signed by the testator, and 3, all of the material terms of the will must be in the testator's own handwriting. The testator must also have capacity to execute a will. The material terms are each gift given under the will, and 2, who each gift should go to. The lack of a date will not invalidate a holographic will, except in certain instances where there is an issue with the testator's capacity, or there is the possibility that 2 or more wills should be probated. Will house to daughter but husband alive. California is a community property state. Therefore, there is a presumption that all property obtained by a couple during marriage is community property. Upon the death of one spouse, the living spouse retains a 1/2 interest in all community property. In the event that a testator's spouses will devises more than 1/2 of the community property, and therefore intrudes upon the living spouse's 1/2 interest, then the living spouse may either elect to take its gifts under the will or to receive its proper community property share. Any property acquired prior to marriage, as well as any property acquired during marriage through the expenditure of separate property, and the profits, rents, and issue arising from separate property, is considered separate property, and is not subject to the community property rules stated above. Ademption. A specific gift may be extinguished under the will in the event that the testator no longer owns the specific property to be gifted at the time of death. However, under California law, a specific gift will not be automatically extinguished because it is no longer part of the testator's estate if it can be proven that the testator did not intend to have the gift redeemed. Intestacy. Under California's intestacy rules, in the event that there is a surviving spouse, the surviving spouse takes 1/2 of all community property and quasi-community property. The surviving spouse will also take a share of separate property, depending on whether the testator left living children. In the event that the testator left a surviving spouse and more than one living child, the surviving spouse receives 1/3 of the separate property passing through intestacy, and the children receive the other 2/3, to be divided equally among them. Valid will. To determine this, we must consider whether there is testamentary capacity, 2, testamentary intent, and 3, formalities have been met. Testamentary capacity. A testator must have legal and mental capacity. First, legal capacity requires for the testator to be above the age of 18 at the time of executing the will. Second, mental capacity requires for minimum mental capacity test to be met. That is, the testator must I. Understand the nature of his bounty, his relationships, 2. Understand the nature of his assets, and 3. Understand the nature of his actions. Testamentary intent. A testator must have present testamentary intent, which can be inferred from the document having material provisions and appointing an executory. Formalities. A will can either be a holographic or attested will. For an attested will to be valid, it must be in writing, signed by the testator, and also signed by at least 2 witnesses. Note that the 2 witnesses must be in the presence of the testator. Presence includes sight, hearing, etc. When the testator signs the will or acknowledges his signature on a will, the witnesses must also understand that they are signing as witnesses to a will. Note that witnesses need not sign the will in the presence of the testator, or in the presence of each other. Witnesses need only sign the will prior to the death of the testator. Interested witnesses. Witnesses who sign a will and are receiving a gift under the will are interested witnesses. Signing of a will by interested witnesses does not invalidate the will. Instead, a rebuttable presumption of undue influence/fraud applies to the interested witnesses. If the witnesses are not able to rebut the presumption, then the gift fails, and the witnesses would only get the amount from the testator that they would be entitled to under intestate succession. Note, however, that a person in the will given a fiduciary title or executory title is not an interested witness. Codicil. A codicil is any writing that can accompany a will. Note that an invalid codicil does not invalidate a will. Further note that a codicil must meet the same validity requirements as discussed above with respect to a will. That is, a codicil is valid if I. Testator has capacity, 2. Testator has intent, 3. All formalities have been met. Holographic will. A holographic codicil must be in writing and signed by the testator. Note that the writing may occur on any paper or surface. Integration. Integration entails that all documents in physical and legal connection will be read together at the testator's death. Note that if there are any ambiguities in a will, the court will consider extrinsic evidence clarifying any ambiguities, whether latent or patent ambiguities. Republication by codicil. When republication of codicil occurs, it cures any interested witness problems. This means that the court will only consider now whether there was any interested witness at the time of the 2012 codicil instead of the 2000 will. Incorporation by reference. Note that the court will likely consider the 2012 reference of MEE will as an act of incorporation by reference. A testator may incorporate by reference any document so long as that document is existing, and it is described sufficiently, and the testator so intends. Here, by referring to his will, Ted is incorporating his will by reference. Since the will existed at the time of the codicil, and the codicil was specific in referencing the will, the court will likely presume that Ted intended to incorporate the will. Residual estate. A residual gift is a gift of anything remaining after the distribution of the estate. Revocation by physical act. A will can be revoked by physical act or subsequent testamentary documents. When revoking by physical act, testator, or someone under testator's direction must burn, tear, destroy, or cancel the will. The testator must have the intent to revoke at the same time. Revival. A will can only be revived if it was revoked by a subsequent testamentary instrument, which was then later revoked by physical act or another testamentary instrument. Revival re-effectuates an earlier will. However, a will revoked by physical act cannot be revived. Holographic will. A valid holographic will requires that all material terms of the will be in the testator's handwriting, and it be signed by her. Integration. A writing that is present at the time of the execution of a will, and is intended to be a part of that will, is deemed to have been integrated into the will, and is probated. An intent to make it a part of the will can be established by it being attached to the will. Incorporation by reference. A writing, whether valid or not, can also be incorporated by reference if it is in existence at the time of the execution of the will, it is identified in the will, and there is an intent to incorporate it. Undue influence. Courts are unwilling to probate wills or terms of a will that are procured by undue influence. Undue influence is when the testator's free will is overcome. There are 2 types of undue influence that the court may find were at play when May wrote the document attempting to revive her former will. Prima facie undue influence and undue influence based on case law. Prima facie. To establish a prima facie case of undue influence, a party contesting the will would have to show her mother's susceptibility to be influenced, her brother's opportunity to influence MEE's active participation in influence, and an unnatural result. Case law. Under the case law method of proving undue influence, there has to be a special relationship between the influencer and the testator, active participation, and an unnatural result. Lapse. Under California's lapse provisions, the gift to the church would lapse and fall into either the residuary clause of the testator's will, and if there wasn't one, then it would pass under intestacy. The gift cannot be saved under the anti-lapse provisions, because only kindred who leave behind issue can benefit from that provision. Intestacy share. Under the default rules for intestate distribution, when there is no surviving spouse, which there isn't here because May was a widow, distribution to issue is on a per capita basis.